everybody. Hey, oh, everybody. And I want two things to happen. My mouse isn't working. It's going to make me angry. Damn it, mouse. Comments. Good evening, viewers. Thank you, Mod. Let me do the thing real quick. Let me do the damn thing. As I say, let's do the damn thing. DJ, spin that shit.
2, 3, 4.
Thank you, DJ. Thank you, audience. Thank you, the world as a whole. We're here today. Let me say, if you have not yet seen the little banner down below, little banner, it is my lovely daughter, Aaliyah's. It is her 11th birthday. My number 2 daughter, my little angel, Aaliyah. It's her birthday today. So, happy birthday, Aaliyah. We call her Babesy. Happy birthday, Babesy. It is Babesy's birthday. So, give it up for Babesy. Give it up. Give all the love to her. I love her. Daddy loves you, kiddo. And we will see you soon and be rolling around in mud and whatever it is you weird 11-year-olds want to putting makeup on my face, looking me look all crazy as fuck. We do that, right? Happy birthday to the Babesy! All right. All right. So now to the matters of the law. Okay. We have here a case called Newman Machine Company versus Newman. So for all those Seinfeld fans out there, we know Newman. Anyways, all right. Newman Machine Company versus Newman. All right. North Carolina Court, 1969 case. The hearing below was on a demurrer. The allegations may be summarized as follows. George F. Newman, Jr., the defendant, owned 64.77% of all the issued and outstanding shares of capital stock of Plaintiff Corporation. In March of 1950, he made a gift of certain of his shares to himself as a trustee for his children. Well, that sounds kind of fucked up, but we'll see how it goes. Thereafter, Newman gave a gift to himself of shares of the stock that he already owned. A little sauce. Thereafter, and until February 6th of 1959, he owned individually 53.299% of the capital stock and owned as a trustee for his children 11.477% of said shares. In addition, he also owned individually 65% of the outstanding shares of capital stock of all the 3 affiliated corporations. On February 6th of 1959, Newman sold the Plaintiff Corporation at $135.25 a share, all of the shares of its stock which he, Newman, owned. This included both the 53.299% he owned individually and the 11.447% he owned as a trustee for his children. The total purchase price was, ready? $785,802.50. On February 5th of 1965, the defendant notified plaintiff by letter that the defendant's attorney was investigating the transaction involving the sale of the stock. On August 27th of 1965, the defendant requested that copies of the plaintiff's audit report for the years of 1957 and 1958 and 1959 and 1956 and 1960. And on November 17th of 1965, defendant's attorneys, plural now, examined copies of said audit reports at the plaintiff's offices. And now, on March 24th of 1966, The defendant's attorneys wrote plaintiff, quoting that the audit reports showed that Newman had been defrauded and the price paid for his shares had been, quote, grossly inadequate. The attorneys said that they had advised Newman that he was entitled to rescind the transaction or to sue for damages, and that he was legally obligated to sue with respect to the shares he owed as a trustee. They said that Newman had requested them to file suit, but that they would be willing to discuss a settlement offer. Defendant, through his attorneys, defendant is Newman, continued to make demands on the plaintiff and threaten legal action against the plaintiff, including the threat of receivership. These threats have seriously jeopardized the plaintiff's corporate existence, hampered long-ranging planning, and seriously affected the plaintiff in the conduct of the business and its affairs. William M. York, senior president of the Plaintiff Corporation, is of 7 years of age and will be a material witness to any litigation. His evidence should be preserved. So that's point 10. Point 11, a real controversy exists between plaintiff and defendant. No shit. The threats construed a cloud on the title of the shares of the stock purchased by plaintiff from Newman as a trustee, and this action is brought for the purpose of settling the controversy and removing the cloud on the plaintiff's title to such the stock as is in question. Plaintiff praised the court for jurisdiction, declaring that it has a good title to the 11.447% of the shares of the stock it purchased from the defendant trustee of Newman as the trustee of the stock, right? Defendant's demurrer was overruled by the trial judge. The Court of Appeals reversed it, and now we're on the Supreme Court of North Carolina to decide this matter. Huskins, the justice, writing the opinion. A demurrer tests the sufficiency of a pleading, admitting for that purpose the truth of factual averments, well stated, and such relevant inferences of fact as may be deduced therefrom. Demurrers in the declaratory judgment actions are controlled by the same principles as applicable in other cases. Even so, it is rarely an appropriate pleading to a petition for a declaratory judgment. Even so, it is rarely an appropriate pleading to a petition. That's what it says. Okay. If the complainant sets forth a genuine controversy justiciable under the Declaratory Judgment Act, it is not demurrable, even though a plaintiff may not be entitled to prevail on the facts alleged in the complaint. This is so because on the demurrer, a court is not compelled or concerned with whether the plaintiff's position is right or wrong, but whether he is entitled to a declaration of rights with respect to the matters that he has alleged. Going to point 1 of the demurrer action. The complaint and the demurrer present the questions that follow. 1. Does the complainant state a cause of action justiciable under the Declaratory Judgment Act? 2. Does the complaint state a cause of action in equity to quiet title to personal property? Now we're going to the analysis of those. Plaintiff contends for an affirmative answer to both questions. While defendant argues an action to quiet title to personality cannot be maintained in this case. These words are crazy. Because there is a statutory provision for such suits only with respect to real property. So basically the shareholders, the shares that they're, so we have shareholders of a corporate entity, right? And we have this really new novel argument that the defendants are raising that's saying, like, we can claim a quiet title action to these shares. But quiet title, for all those out there listening, right? Quiet title is only traditionally a cause of action in a case for real property, for a piece of land and a house on it, not for shares of a stock in a company, right? So going back, right? Because there is a statutory provision for such suits only with respect to real property, not to stock property. So, quoting from North Carolina General Statute, Section 41-10, defendant further contends that the type of dispute pictured by the complaint does not qualify for consideration under the Declaratory Judgment Act because A, a genuine controversy does not exist, and B, because the action does not include all necessary parties, and C, the action involves primarily issues of fact rather than questions of law, and D, because the object of the action is to bag in advance. What's this funny language? To bag in advance an impeding lawsuit by becoming plaintiff now so as to avoid becoming defendant later. Okay, so by bag in, they mean to preemptively make a lawsuit now as a plaintiff because you know you would be responding later on because you're doing something so wrong that eventually they would sue you. So you're suing them first. But it's what bag in apparently means in North Carolina. Don't go to North Carolina if you can help it, people. All right. The excellent briefs of both parties are largely devoted to discussions of whether the complaint states a cause of action justiciable under the Declaratory Judgment Act. We find it unnecessary to decide that first question. So, that was great. You put all these briefs out. You're great briefs. Well, we don't care about that. We're not. Even though you made very great briefs about this question, you did a good job. We're not deciding on that question, so piss off. Right. That's what the court says. We hold that the complaint states a cause of action to remove cloud and quiet title to personality, and that such an action may be maintained in the state. So in North Carolina, the court is saying that you can hold a quiet title action not just to real property, but to shares in a stock corporation, shares of stock in a corporation that is incorporated within North Carolina. Pretty remarkable. All right. We find it unnecessary to decide the first question. However, in view of the conclusion we have reached on the second. So they're saying that the first issue that's been heavily briefed, we're not listening to. The second issue about the quiet title, we're listening to. So now we'll go into analysis about the quiet title. We hold the complaint states a cause of action to remove the cloud and quiet title to personality, and such action may be maintained in the state. Since the courts generally apply the same principles, when title to personality is involved, as they do when title to land is clouded. Brief reference to some of the requirements in equity suits to remove the cloud and quiet title to realty prior to enactment of North Carolina Code General Statute 41, Section 10. Is helpful to an understanding of the question before us, and under the old equity preface, quote, a bill quiete timent, literally because he fears, was intended to prevent future litigation by removing the existing causes which might affect the plaintiff's title. If one in possession of land under a legal title knew that another was claiming an interest in that land under a title adverse to him, there was no adequate remedy at law for such an occupant to test the validity of his claim. Being in possession, he could not sue at law because he already owns it, right? You can't sue yourself for shit you already own, right? And the adverse claimant would not sue, so that the adverse claim might be asserted at some future time, when the evidence to rebut it might be lost, or, at any rate, the existence of such a claim casts a cloud upon the title which would affect its value, right? If you own a Whataburger and somebody else is saying they also own the Whataburger, right, and you've owned the Whataburger for 20 years, and you're trying to sell it, right, the fact that somebody else is saying, no, actually, I own this Whataburger, right, clouds your title. You don't have a clear title in possession so you can get the full value for your property. It would diminish the value. And so we want the court to issue a judgment saying who really owns that title to get the full value for their title, right? All right. Andrew Campbell McIntosh who apparently wrote a book called North Carolina Practice and Procedure in Civil Cases, good for him, said that prior to 1893, well, this is a 1969 case, so yeah, prior to 1893 would probably be relevant to some extent, right? Prior to 1893, in equity suits to remove cloud or quiet title to realty, plaintiff was required to allege and show three things. First, that he had no adequate remedy at law. Two, that he was in rightful possession of the land in question. And three, that the defendant's adverse claim was such as to affect plaintiff's title injuriously. Basically, like that his asserting his claim to title injured or was in conflict with the other guy's claim to title, right? In Busby versus Lewis, a plaintiff sought to remove a cloud upon the title, and he was denied equitable relief because a valid legal objection was apparent on the face of the record. Quoting that court, a court of equity will not remove a cloud based upon a deed alleged in the complaint to be void upon its face, since if it really be so, the party has always had a hand in a certain defense against the deed, whether it may be argued against him or not. Well, that court said a lot of nothing. Fair enough. Because the General Assembly considered Busby an inconvenient or unjust application. Okay, so basically the court said, yeah, that's a bunch of bullshit, because it kind of is a bunch of bullshit, right? The court considered Busby, which was the decision we just read, right, an inconvenient or unjust application of equitable doctrines involved in acting in North Carolina General Statute 41-10, providing that an action may be brought to any person against any other who claims an estate or interest in real property adverse to him for the purpose of determining such adverse claims, end quote. That enactment was designed to avoid some of the limitations imposed upon remedies formerly embraced by a bill of peace or by a bill of quieta timent, quiet title in the modern English, right? And to establish an easy method of quieting titles of land against adverse claims. Since we have no statute regarding suits in equity to remove cloud or to quiet title to personality, personality means like, okay, you have real property, which is the property you own, the land, the house. What this court is calling personality means shit that you own, stuff that you own, sorry. Like your stock options, which is the subject of the law in this case. So they're saying here that there might be an extension of your personal space to also include the things that you own, right? And there's no statute regarding equity as it concerns the stuff that you own personally, okay? The only statute, North Carolina Statute 41, Section 10, only applies to real property holdings, not to personal property, including stock options, okay? Okay, although such suits were usually brought only in cases involving real property, the generally accepted view is that a bill to quiet the title or to remove a cloud on the title to personal property, so that's stuff that it's not real, it's not a land, it's stuff, it's a car, it's a dog, it's stuff, it's your CD collection, your collection of Thai Beanie Babies from 1990, right? Those are all part of that, right? Those are personal property, okay? Must be generally accepted and be properly maintained in equity in the absence of a statutory authorization whereby reasons or of exception or circumstance there is no adequate remedy of law. It was held that a cloud upon the title to personal property in the form of a recorded chattel mortgage could not be removed. But Pomeroy, who's an old-ass justice of the North Carolina court, says that, quote, there seems no good reason for those restricting the jurisdiction, and the instances are not infringement where it has been exercised in good reason for void of recorded chattel mortgages, spurious issues of stock shares in stock, etc., from a 1919 case. That's why I read it in that voice. Even though there is no statute in North Carolina that authorizes suits to quiet title to personality, we adhere to the general rule that such suits may be maintained in equity while there is exceptional circumstances. There is no adequate remedy at law in this case. Here, the plaintiff is in possession of the stock it purchased from the defendant trustee, and the defendant is claiming an interest in it adverse to the plaintiff. So the plaintiff bought the stock from the dude, and the dude is saying that for whatever reason he still owns the stock. Like, you bought it from me, you paid me the $785,000, but I still own it. So they're claiming by adverse possessory interest, they mean that both these people are saying they own the same thing at the same time. You can't own the same thing at the same time. Only one or the other is possible, right? All right. Okay. So, being in possession, plaintiff cannot sue at law, and defendant will not sue. At least he has not done so during the almost 2 years of his threats and demands. Newman. His adverse claim may be asserted in court at some future time when the plaintiff's evidence to rebut it may be lost. The existence of such a claim casts a cloud upon the plaintiff's title to the stock and may adversely affect its value. Because if you're like, hey, half the stock is mine, and you're like, no, it's all mine, I'm going to invest it, I'm going to do stuff with my company, and they're like, no, it's mine, then like when you publicly trade your company on that stock, right, and there's some asshole out here yelling, it's actually mine, right, that could affect how people would want to buy or not buy your stock, right, because that would impact the valuation of it, right? So that's what the real thing, there's the real issue here is about, right? Under these circumstances, the plaintiff is entitled to invoke the equitable assistance of the court to remove the cloud, to remove this bullshit hanging over the stock, right? And quiet the title to the ownership of said stock when the defendant, for whatever reason of his own, continues to threaten, but refuses to actually act on those threats. The defendant's like, oh, I could sue you so bad, bro, I could sue you next Monday, but doesn't actually file a lawsuit. So because he's not filed a lawsuit, the people who he might someday sue can't respond to him in court. Like, you can't file a suit under a law that says, I'm going to sue this guy because he might be going to sue me. You can't do that. The party has to initiate the suit, and then only in response can you reply to that, right? So this is asking the court to sit in equity and say, look, this guy's been out here on the perimeter dancing around half naked with his bullhorns and his blue face paint saying, I'm going to sue you, I'm going to sue you. And we're like, okay, the fact he's doing that is hurting the value of the stock that we own. So court, even though he hasn't sued us yet, we want you to issue a declaratory judgment saying that he cray-cray and he can't sue us for this, to eliminate the threat of his lawsuit, right? Which then makes our stock perform on an actual traditionally valuable basis, right? And the court affirms that here. So they say, with ever-increasing importance of personal property in the business world today, especially of stocks, bonds, and other intangibles, there is no sound reason why the equitable remedy, the equitable remedy being to determine this upfront, right, should not be available to quiet the title. Be quiet the title means to be like, dude over here dancing around the blue face paint and the freaking sheepskins, go away. Your title that you're claiming, it's quieted. Go away. You don't have it. No mas for you. Okay? And we're going to go back now. And the person who had the rightful stock held, right, can be determined to have that stock rightfully in their possession before we need an asshole out there to sue us. We can say, he's been dancing around with flames, he's been blah, 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 and we're going to let him keep doing that, but we're going to make sure that our rights to the stock we rightfully bought for him for $785,000 means it's actually our stock, not his stock, and we'll go forward from that. And so because of that, the court reverses and remands the lower court's decision in accordance with what we just talked about. So it's going back down there and saying, like, bad Newman, bad Newman. You sold the stock. You don't get an interest in it because you sold it, bro. So there's the deal with. All right. So again, just and this we're the halfway, well, probably over halfway point because this next case is not very long. But just want to say again, happy birthday to my baby girl Aaliyah, my babesy. My little 11-year-old daughter. She's so pretty. She got a vanity. We got it for her birthday. She got some makeup. She doesn't know how to use it. She looks crazy when she puts it on her. It's a train wreck, but we love her. Anyways, love you, kiddo. It's true though. She like looks like the queen of the damned. She's like, I'm put makeup on. I'm like, whoa, because she doesn't know how to blend. So she's if we'll just talk for a second. We're just friends. We're just friends here. We'll just talk. So my child is a mixed child. She's half black and half white, and she doesn't quite understand how makeup and foundation works for somebody who's not white and who's not black and is in the middle. And so she puts on a foundation that like either like that Keanu Reeves should wear or that like Wesley Snipes should wear. And she can't get like so either she looks like she's been punched in the face 5 times or she looks like she's trying to be Michael Jackson doing whiteface. And that's just I guess that's the plight of a mixed kiddo in 2024 America who just turned 11 and went to Sephora for her birthday and got a vanity for her birthday and got foundation and she's trying to figure out how to blend stuff and yeah, it's Wesley Snipes on one side, it's Keanu Reeves on the other side, it's like the Batman villain of Two-Face, and I'm not sure which child I'm talking to in the morning because she doesn't. She'll get it. She'll get it. We for her birthday we've gotten her plenty of makeup from Sephora, a whole gifty packy, and a nice lovely vanity that she can she can spend as long as she wants figuring her life out and figuring which half she wants to be on any given day. I love you, Aaliyah. I love you, Babesy. But I'll reserve my comment until you figure out the blending. Yeah, figure out how to blend. I hear on YouTube there are a lot of Korean people of Korean folk who do the blending and they that's what they do and they're like, oh yeah, blend. So the baby, you're a mixed child. You need to blend. It's not like it's not it's like it's not even like Keanu Reeves. It's like Heath Ledger's Joker on one side, and the other side is like Wesley Snipes in freaking New Jack City. So I mean, I'm just like, I mean, more power to you, kiddo. But the blending is not happening. We need to work on that, and that's. I'll take my dadly duties and try to help with that. However, I'm probably gonna fuck it up worse than she does, to be honest. But we'll see what we can do. We'll see what we can do. All right, so to that point, we're on to Reformation, not the Protestant Reformation, Reformation of a contract. We're talking about, ironically enough, a case called Hand versus Dayton-Hudson, a Sixth Circuit Federal Court decision from 1985. That's funny. The chief judge's name is Lively, so Judge Lively, well, better than Judge Deadly, I suppose, writes the opinion. Plaintiff John Hand. That's like a freaking terrible Saturday Night Live skit masturbation name. John Hand. Oh, John Hand! Let that pass. Plaintiff John Hand appeals from the entry of summary judgment in favor of defendant counsel Dayton-Hudson Corporation and the diversity action alleging a breach of an employment contract and age discrimination. Don't discriminate on the ages. The district court found that Hand had fraudulently altered a release. Hand had fraudulently altered a release. I'll let you make of that wording what you will. And he fraudulently altered the release to conform to its original meaning. And because of the reasons set forth by the court below, this court, the Sixth Circuit, affirms. Let's figure out what the hell they're talking about. The historical facts are undisputable. That's great. Appellant Hand is an attorney. Oh, he's an attorney. And had been employed by the appellee, Dayton-Hudson Corporation from 1967 to 1982. In February of 82, he lost his job, allegedly as a result of a major restructuring by Dayton-Hudson. Upon firing the Hand, Dayton-Hudson made an offer to pay him $38,000 if he agreed to release them from any claims he might have against them in liability. Sounds like a guilty conscience. Hand refused the offer, asserting that he was already entitled to that sum under his employment. Oh, God, he's an asshole. He said he's already entitled to that sum under his employment contract and more under claims and liability. And even though that was the thing that they said, they drafted a release form according to the terms that were already stated by Dayton-Hudson, and it was given to him for his consideration. And he was told that he must either accept or reject it by March 20th of 1982. On March 19th, he met with them, and the parties signed the document that he brought with them. So, they made a release. They're like, here are the terms for your release, bro. And he's like, I'm not going to do it. And they're like, okay, fine. Well, we're going to draft up terms and put them on paper, and you're going to have a meeting with us, right? He's like, fine. I'll go to your meeting. I'll just go to your meeting. Fine. And they go to the meeting. And he goes to the meeting, and they're like, here are the terms. Here's a paper. Like, all the terms. All the terms we said to you were bitching about, here they are. He's like, I guess I'll sign it. Fine. And he fucking signed it. They both signed the document, which was inclusive of the same terms that were brought to him. So, apparently, prior to that signing, Hand, our villain, our dude, the dude of the hour, right, had prepared another release, which provided that he was releasing all claims, quote, except the claims of age discrimination and breach of contract. Except for the changes made by Hand to limit the terms of relief, Hand's release was identical. So basically, they came with one document. He came with another document that said, except for age discrimination, we're good. But he signed the document that they brought that he didn't bring, that didn't have the age discrimination thing in it. Anyways, Hand's release was identical to the original prepared by Dayton-Hudson. The typewriter on which it was written was the same type and model. He even wrote it on the same effing typewriter. The number and structure of the paragraphs were identical, and all other language and punctuation was identical. And the headings are also all identical. Hand attached the outline of termination benefits to this release in the same manner that had been attached to the original release, despite the changes that he made to the documents. OMFG. This dude, this isn't like 87, 80, 1980, 84. This dude typed up on his own an identical freaking contract to what they were bringing, and then tried to use his one that he slid in 2 extra sentences to. He tried to freaking Skype in or Skype in his version over theirs and tried to make them file his fake version. He had it down to the typewriter, the font, the headings, the everything. This is a smooth operator. And he's trying to be like, oh yeah, here you go. Because there's no Word document. There's no track changes. There's no compare files. It is a typewritten document. He's like, oh yeah, here you go. Here's what you want. But he's like taking theirs that looks exactly the same and putting it in the trash can and giving them his, which has 2 extra sentences added in about age discrimination. This is extra, right? So, Section 2. Upon review of the district court's grant of summary judgment, the court must determine whether there was any genuine issue of material fact when this evidence was viewed in light of the most favorable to the party opponent in the motion. Hand, who's our bad guy here? Hand, evil master Hand. Hand, yep. Hand is New Newman. Newman is Hand. Asserts the district court erred in finding that on summary judgment that the motion he had not given. Remember what I just told you about how? So the district court, the trial court, right, was like, bro, the whole paper thing you did, we have a word for that. It's called fraud, and you're guilty of it. And so now he's appealing that and saying, no, that's not a fraud. That's not a fraud. So to read the court's words here, right? Hand asserts the district court erred in finding on summary judgment that he had committed fraud. So he's saying, oh, they were wrong. It wasn't a fraud. I didn't commit a fraud. They were wrong when they said I committed a fraud. Oh, no, right. Oh, my God. He also asserts that summary judgment was inappropriate because reformation is not a proper remedy when there is not a mutual mistake of fact, even in the present fraud. Okay, so here's the whole thing, right? So remember the facts of the case. There was a corporation that typed out the terms on a typewritten 1985 or 1982 document, right? Typewritten, headings, whatever. He made an identical copy, but put in 2 little extra sentences under age discrimination. He took the original party's document, pocketed it, and put his back in. It's like, oh yeah, that's totally what we agreed to, man. Sign that shit. We're good, right? And they did. And then they found out that the document they signed was a fraudulent copy. It was the one that he fraudulently put extra shit in and said that he agreed to because he was agreeing to a fraudulent copy, not the actual document. And now the district court said, yeah, bro, yeah, you committed fraud. And he's like, no, I didn't. And the reason he says he didn't is because he said, so his argument is that it was a mutual mistake. Mutual mistake is a contractual term that says that, oh, well, we both screwed up. Like, my contract wasn't exactly right. Their contract wasn't exactly right. We're okay, right? And the court's like, no. Your contract is a fraud. Their contract was a real contract, and you lied to them and said the contract you signed was their contract, but it wasn't. It was a fucking fake contract. You tried to make them believe was their contract. And we have a bit of a problem here. So, to part A sub 2 of the decision, Hand, in his affidavit, stated that he prepared the release knowingly and deliberately. Well, so he's just said the fraudulent document that he prepared, he signed an affidavit saying, yep, I did that. I did that knowingly and deliberately. That was me. Oh. He did it knowingly and deliberately because he intended to turn the tables on Dayton-Hudson. Hand committed fraud by not informing Dayton-Hudson of the changes he made in the release. So in his affidavit, he said he knowingly committed fraud for the purpose of, quote, turning the tables on the company he was employed by. A practice note of any of you out there who want to commit fraud one day, don't admit to it. And if you admit to it, don't do it because you're like, well, I was trying to stick it to him. I committed the fraud because I was trying to turn the tables on the man. You know what I'm saying? I want to fucking turn the tables, but you're good. Well, that doesn't bode well before the court. All right. The defendant was excused from... Oh, my God. Okay. So the defendant, which is the people he committed fraud on, right, was excused from not having read the new document because the general rule being held responsible for contract once signed because the individual was not aware of the actual document before them that was being signed because he slipped a fake document in there. It was like, sign this one instead. Because the company made the original document and this guy copied it and put extra fake shit in there and then signed it and gave it back to them. They assumed the document they were giving back was the document they gave him to sign. They didn't assume he palmed the document they gave him and gave them a new fake document. So now he's trying to claim that, well, they obviously had to have read it because they signed it. It's like, bro, you gave them a fake duplicate document and they signed that fake ass one. And so the court's not hearing it, right? All right. It is not applicable when the neglect to read is not due to carelessness alone, but due to the direct inducement of a stratagem, trick, or artifice on the part of the other party who's seeking to enforce a fraudulent contract. So, like, yeah, if you like, woo, hocus pocus, poof, here's a new contract, right? Same thing I was just saying is like, it's not your fault if you didn't read it. If they make a fake bullshit contract in front of you, they just like, whoa, put it up there, and you have to then respond to it, right? Because that doesn't count. Because you gave him a contract that you wrote, and you're like, sign this. He's like, oh, sign it over here. He's like, here you go, I signed it. And then all of a sudden, hocus pocus, abracadabra, there's two new sentences in there that he fakely put in there, right? It's not your fault to have read that because he faked the funk, right? All right. So now in part B of section 2, Appellate Hand further contends that the Reformation, so he's calling his addition of fake shit reformation of the contract, we'll see how this goes, is not a proper remedy in this case. Under Michigan law, reformation generally requires a mutual mistake of fact. To grant reformation when there is merely a unilateral mistake, by unilateral mistake being you unilaterally forged shit, you unilaterally committed fraud, we can call it a mistake if you want to, would be harming one party while benefiting another without regard to what the party actually intended. That's about right. This would be equivalent to drafting a new contract between the parties, which courts are reluctant to do. However, there is an exception to the requirement for mutual mistake under Michigan law, which is, quote, where the mistake is on one side and one side only, and the fraud or inadequate conduct is on the other side, equitable conduct is on the other side, reformation may be decreed. I apologize. To use this exception, the finding that one person knew the writing did not reflect the other party's intent must be supported by clear and convincing evidence. This exception is consistent with the restatement of contracts, which provides that if a party's assent is induced by the other party's fraudulent misrepresentation as to the contents or the effect of the writing, the courts may reform the writing to express the terms of the agreement as asserted. So this is the exact opposite. So they're saying that if you give somebody a good, valid contract, like here's a fair, honest contract, right? And somebody goes and F's with it, like squiggles out words, whatever, like here's my new contract, right? The court is gonna find that. So okay, step back. Reformation is taking a contract that has some issues with it, right? And the court's going to read it in a certain way that makes it a whole, proper, enforceable contract. And the only way the court is going to do that in the case where there's fraudulent misrepresentation is to cut the fraud out and say, okay, here was all the fraudulent bullshit you put in the contract. We're cutting that out, and we're going to make a new contract with the non-fraudulent crap in it, right? And this jackass, Mr. Hand here, is arguing, no, we need to do the opposite. We need to set, I want you, the court, to redraft the contract to include all the fraudulent shit that shouldn't have been in there. The court's not having it, but you see how there's like, and the Hand apparently was a lawyer. So don't trust lawyers, people. Like, don't trust them. Don't trust a hoe. And don't trust the lawyer neither. So, all right. The appellant asserts that this exception can only be invoked where there has been a meeting of the minds regarding the terms of the release. And since appellant never intended to release the asserted claims because appellant never saw them because he just stuck them in his freaking fake contract he wrote up, right? He argues there was no meeting of the mind. The interpretation of the law is too narrow. This interpretation of the law is too narrow. Although some Michigan cases involve meeting of the minds fact patterns, other cases suggest that the exception to the mutual mistake requirement is designed primarily to combat the inequities which are naturally result from a fraudulent inducement of the innocent party to sign a contract the guilty party knew did not reflect the other party's intent. This is the opposite. The guilty party who's been convicted of fraud is trying to say, well, yeah, I frauded them, but they signed it. They signed it, so make them obey it. It's bizarre world. It's opposite day. Mr. Hand here wants it to be opposite day, and it's the court, thank God, doesn't think it is, right? Hand's conduct falls squarely within the exception established by the Michigan case law. Hand was aware that Dayton-Hudson position, and he intentionally modeled a new release after that order. He intentionally crafted his fake-ass contract after the model he was provided. His obvious goal was for Dayton-Hudson to believe that signing it was signing the original document that it had given Hand, and that Hand was accepting Dayton-Hudson's offer rather than making a fraudulent counter offer. Therefore, since there was a mistake by Dayton-Hudson, which was induced by Hand's fraud, the district court correctly applied the Michigan law by reforming the release to say, F you, Hand, you can't screw with them like that. Or as the court says, by reforming the release to conform to the defrauded party's understanding, to conform the release to conform to the people he frauded. Like basically what they thought it was before he frauded them, right? Accordingly, the judgment of the district court is affirmed. Yep. And that is Remedies for today. Hey, thank you all so much for being with us tonight. Hey, viewers out there. And also my lovely daughter, Aaliyah. Much love, my little kiddo. My number 2 daughter. Not number 2 in love. Number 2 is in, I have a 13-year-old, and she is a 10, now 11-year-old, a beautiful little kiddo. If you want to check out the freaking YouTube page, there are videos up here of her up there doing scooter stuff and doing a ropes course with me in St. Louis. If you want to know who the babesy, who the number 2 daughter, who the birthday girl is, you can find her on the YouTube page. And other than that, just, hey, thank you all, and God bless you all, and fuck frauds. Just fuck frauds, man. We don't need none of that. All right, we'll be back tomorrow. Also, stay tuned this weekend. We have another Wound Speaks National Poetry Month writing workshop. We're going to be doing live here on Saturday night. And on Sunday, we're going to be doing more of the Phoenix Wright Ace Attorney, or Phoenix Wright Attorney at Law, Phoenix Wright Ace Attorney series. We have new voice actors coming in. We're going to be, the whole thing is going to be up here. So it's going to be great. It's going to be hot. We can do some more law student reads Phoenix Wright Ace Attorney with multiple multiple voice actors who are doing law stuff. It'll be great. Hey, God bless you all, and happy birthday to my lovely daughter. Yeah, hey, thanks. It's been a great night. God bless you all, and thanks for hanging out. And I'm going to land my plane. Boom. Wait, I have to go right.